Schools and hospitals bombed, strikes on apartment buildings, energy facilities targeted and attacks on neighbouring states. Have Israel, the US and Iran broken international law with their war? Or will they be able to justify their actions? This is Inside Story. Hello again, I'm James Bays. A social media post by the US President Donald Trump on Monday gave some hope for an end to hostilities between the US, Israel and Iran. Whatever happens next, the conflict has again raised questions about the role of international law in modern warfare. Civilian facilities, including hospitals, schools and energy facilities, have been attacked. While Iran has suffered the most civilian casualties, there have been deaths and injuries in Israel too. Neighbouring Gulf states have also come under attack, with vital energy sites, airports, residential buildings and hotels among the targets. So, has international law been broken in the war by the US, Israel and Iran? Or do those same rules provide a defence for some of their actions? In a moment, we'll be joined by a panel of guests, but first this report from Imogen Kimber.
All sides in the war have been accused of breaking international law. The conflict began with US and Israeli strikes on Iran, without any approval from the UN Security Council. On the first day, a girls' school in the south was hit, with more than 170 people killed, mostly children. And US and Israeli bombing has frequently hit other civilian facilities and residential areas. Iran hit a hospital in southern Israel and used cluster warheads in Tel Aviv, causing damage to homes and apartments. Energy sites have been targeted across the region. Israel attacked an oil storage facility in Tehran, a black cloud forming over the city with fears of future health consequences from the toxic fallout. The US hit Karg Island, a vital hub for oil exports. And Israel has struck Iran's gas production facilities in South Pars Field. Iran hit Qatar's Ras Laffan industrial hub with serious impact on global gas supplies. It has also targeted energy production operations in Saudi Arabia, the UAE and Kuwait. Pleas for restraint have gone unheeded.
De-escalation and dialogue are the only way out. And I strongly urge all parties to cease the hostilities, uphold international law, protect civilians and return immediately to the negotiating table.
The UN's nuclear body has said nuclear facilities must never be attacked. But the US and Israel have targeted Iran's Natanz and Bushehr sites. And Iran has struck the town of Dimona in Israel, close to a nuclear research facility. Iran has effectively shut the Strait of Hormuz, a vital channel for global energy supplies from the Gulf. Its northern shoreline is Iranian territory, and Tehran has only allowed some ships through. The law of the sea says international shipping lanes should remain open. However, a country is allowed to block vessels belonging to a state it's at war with. Hitting any civilian facilities is a breach of international law.
Attacks targeting civilian objects or infrastructure indispensable to the civilian population constitute serious violations of international humanitarian law and amount to war crimes.
But despite these calls and warnings, attacks across the region continue. Imogen Kimber, Al Jazeera for Inside Story.
Well, let's discuss all of this further with our guests today, all prominent legal experts joining us on Inside Story. From Canterbury in the UK, Geoffrey Nice, barrister and human rights lawyer. In Washington, D.C., Brian Finucane, Senior Adviser with the US Programme at the International Crisis Group. And also in the UK, in Sheffield, is Nicholas Tsagourias, Professor of International Law at the University of Sheffield. Thank you, all three of you, for joining us. Perhaps today we have a little bit of hope with comments from Donald Trump about fresh diplomacy, but the questions about accountability in this war are going to remain, Geoffrey. Let me take you back to the first day of the war, the last day of last month when this started. It was started by Israel, then the US, firing at Iran. Was that legal?
The only basis for its being legal was that there was an imminent threat to which they were entitled to act. in defense, no evidence has been provided of the alleged imminent threat, despite being raised and requested on several occasions. Therefore, at present and prima facie, the attack was not lawful. It may be helpful as one additional observation at this early stage of our discussion to say, however much people may dislike the present regime in Iran, the way to approach the question of legality is simply to consider first a conflict between two states and one state in the form of a war launched by the two states against another state, and to assess whether that can be legal. And for that simple question, the question is, was there an imminent threat? Evidence there so far has been none.
Brian, the law we are talking about here is 81 years old, is it not? I've got it here. This is the UN Charter, the founding of the UN. Just to give a little bit of context for our viewers, the key parts of this, as I understand it, are Article 2, which says that one country cannot attack another country, and Article 51. Give us a little bit more on that.
That's correct. So it's important to recognize that the UN Charter and its prohibition on the use of force contained in Article 2.4 comes out of the bitter experience of two world wars and the horrors of the Holocaust. Tens of millions of dead, and a desire, including on the part of the United States, who's played a critical role in establishing the UN Charter and the United Nations in preventing a repetition of those horrors. So Article 2.4 of the UN Charter prohibits the use or threat of force by states in their international relations, and that is subject to narrow exceptions, including as preserved in Article 51, the right of individual or collective self-defense in the event of an armed attack, to respond to an armed attack. And just to follow on from something that Sir Geoffrey said, the Trump administration has been asked repeatedly over the course of the last week to substantiate this claim about an imminent threat. The Director of National Intelligence was grilled on Capitol Hill last week about this, and she was unable to factually substantiate these claims about there having been an imminent threat. Instead, she simply asserted, well, it's the president's decision, and he decided there was an imminent threat, and that's that.
So, Nicholas, Article 51, you can either launch a war under the Charter with Article 51 if it's self-defense or if there's a resolution from the UN Security Council. There is no resolution. Article 51, as you've just heard, and as you're well aware, allows self-defense. But this whole question of whether that can be preemptive, what's your view on that? And what's your view on the bigger question? Was it legal?
Yes, thank you very much for having me. I respectfully disagree with my co-panelists. The action is lawful action of self-defense against an imminent threat. An imminent threat of nuclear attack or attack with ballistic missiles. We have to remind ourselves that the Iranian regime has vowed to destroy the state of Israel. Death to Israel is part of its daily ethos and diet. It is ideologically, military, and politically attached to the destruction of the state of Israel. So Article 51 allows for the inherent right to self-defense, which includes the right to preemptive self-defense against an imminent threat. And an imminent threat is interpreted in a very contextual way, and not in a temporal way only. So an imminent threat has to do with the nature of the attack, the means used for the attack, the ability of the state to deter the attack, and it's not necessarily with the time. Also, I have to say that as regards the evidence, states under international law, they don't have an obligation to provide evidence. The decision to go to war to defend the state and their own people is a sovereign right of the state. And in response to what was said about the UN Charter, that it is 80 years old, yes, it is. Therefore, it needs to be interpreted in the context of contemporary threats. For example, if we have a threat of an attack by weapons of mass destruction, we cannot expect the state to react only when the attack is immediate, is about to take place, because that is too late. So, in my opinion, the action, the Israeli and the US action, is a lawful action of self-defense against an imminent attack by the Iranian regime.
Okay, Geoffrey, I want you to pick up on that, an imminent attack, because there's some context here, isn't there? If we go back to that date when this started, 28th of February, there was active diplomacy going on. There was our diplomatic off-ramp. There were talks taking place that had been taking place. In fact, the mediator, who was the foreign minister of Oman, said that they were making progress, even said a breakthrough was possible, and they even had more meetings planned.
The last contribution would suggest that at any time over the last months and years, this attack could have been mounted, because at any time it could have been interpreted as imminent. The reality, as you have reminded us, is that exactly the opposite of imminent was evidenced, both by what seemed to be negotiations capable of going further, and now, of course, by the resignation of a Trump-supporting right-wing expert who says there was no such imminent threat. So I regret I can't accept that the overall proposition that there's no evidence shown for the legality is established. I don't challenge overall the generalizations made by the previous contributor, but they simply don't apply in the very particular circumstances of this case.
Within hours of the war starting, Brian, there was a meeting of the UN Security Council, which clearly is a legal but also a political body in this regard. The UN Secretary General made it quite clear he thought that international law had been broken by Israel and the US, but then by the Iranian response as well, because they hit the Gulf countries. Do you agree with that?
It could well be possible that multiple parties in this conflict are violating international law, both the prohibition on the use of force and with respect to the conduct hostilities, violations of the law of war. I would simply also add, in terms of the context here, the U.S. attack on Iran and the U.S. greenlighting Israel's renewed attack on Iran would not have happened but for the tactical success of the U.S. intervention in Venezuela. President Trump was running a sugar high after that military spectacle, and you heard in the days following threats from the president against Cuba, Mexico, renewed threats of annexation against Greenland, and of course against Iran. The specific timing of the attack, the Israeli-American attack on the 28th of February, was reportedly driven by a target of opportunity to attack the Iranian supreme leader. Okay, so there's no indication in the public record that this was motivated by an actual imminent threat. And it's also important to recognize that Iran, of course, does not and did not possess nuclear weapons, does not have a nuclear weapon to either threaten the United States or Israel with.
What do you make of those points, Nicholas? Your fellow panelists are saying there was nothing imminent and that Iran did not possess a nuclear weapon. Yes, they had a nuclear program, but they've always said they don't have a nuclear weapon. And those that have examined this say they didn't have a nuclear weapon. And, of course, diplomacy was underway.
Well, there is a permanent threat, a source of threat, which is the regime in Iran. As I said, it is determined to destroy the state of Israel. So the source of the threat is there. And unless the regime is removed, the source will remain.
But if they don't have a weapon, where is the threat?
The threat is the program to develop nuclear weapons, because to allow to develop weapons will be too late to act in self-defense. And of course, they have program to develop long-range ballistic missiles that they are using. And of course, they can go covert. So international inspections may not work. And it all depends on the cooperation of Iran. And the cooperation is not forthcoming. Also, with regard to the negotiations, I think both parties said that they were in bad faith. Of course, negotiations cannot go in eternity. Negotiations, there can be a point where reasonable people can make a decision that the negotiations are not productive. And in this case, you had the negotiations that at some point they stopped, and then you had the action. So negotiations are not the only means of dealing with the issue or the threat that Iran presents, which is an existential threat to the state of Israel.
It's worth noting that there was a nuclear deal that was in place with the international community in Iran until President Trump tore it up, the 2015 nuclear deal. Geoffrey, I mean, what do you make of the views of many Western politicians of the legal situation? Because when you're dealing with the UN Security Council and UN resolutions and the UN Charter, all of this is legal, but it's also political. And EU leaders were so hot on international law with regard to Russia's invasion of Ukraine. When it came to this, you heard them talk about international law, but then condemn very much Iran without any blame to Israel and the US for starting it.
We need to accept that accountability for breaches of international humanitarian law, the law of war, by large countries such as Russia, America, China, and those they favor, such as Israel, are now unrealistic and things of the past. As has been made quite clear by the Secretary of War, Hegseth, there is no respect for the law because politics takes over and politics does not have to regard the law.
But Geoffrey, this has been your entire career, I know, but does it mean that international law and these standards that have been built up over the years since World War II are not really worth the paper they're written on anymore?
I hadn't said that, and I'm not going to say that. What I'm saying is accountability, so far as large countries are concerned, is unrealistic as something for us to expect or hope for. The period of time since the beginning of the ad hoc tribunals for Rwanda and so on, leading up to the creation of the Criminal Court and the International Criminal Court and since, has seen an identification, a clarification, and possibly an expansion of the international humanitarian law. And that law can and does still apply. Sometimes it can apply in big conflicts, such as when South Africa was able to bring a case against Israel in respect of Gaza at the International Court of Justice. With what effectiveness, we don't know, but to some extent, there has been an accountability process of a kind started. But also the international law, humanitarian law, as developed, can be applied in many other ways. First, because it can be properly applied by countries such as the United Kingdom in deciding what its response should be, because it may say, well, there may be no accountability for the countries that are committing this war in due course, but we are going to act in a way that we say, and it's for Parliament and others to decide whether they're right in this, that we say is legal within the law. And the law can also be applied constructively in other ways. In civil actions, stopping companies, for example, helping countries that may be committing unlawful acts. The countries may not be brought to book, but the companies, commercial companies that support them and can be attacked through their pockets, can be. So the law is not dead and gone, But we have to accept that we are now living in an age when big countries do not regard the law of war as constraining their actions.
Brian, you used to be a lawyer for the US State Department. You just heard about, he calls himself the Secretary of War, the Secretary of Defense, Pete Hegseth. There was a quote from him in one of his briefings. He's been very combative in his briefings. We will keep pushing, keep advancing, no quarter, no mercy for our enemies. Well, no quarter, it's a historic phrase. It implies that combatants will not be taken prisoner. They will be executed. Were you shocked by that language?
Yes, and notwithstanding his long history of denigrating the law of war, denigrating military lawyers, and even advocating on behalf of accused war criminals, it was shocking, if not necessarily surprising, that he would say such a thing. And it's important to understand why. Denying quarter and the mere declaration that there shall be no quarter can constitute a war crime under the law of war. And so the Secretary of Defense's mere words in this context could itself constitute a war crime both under international law and U.S. domestic law. Now, I agree with what Geoffrey said about international law and the law of war not necessarily shaping decision making of this administration at the front end. But I think there is a choice going forward for future administrations as to how it handles accountability. Will it try to rebuild some of these international law guardrails? Will it try to hold figures in the current administration accountable in some ways for the various abuses, including the unlawful use of military force?
Nicholas, I mean, we have seen, as always in war, lots of civilians die, but some of the instances have been really horrific. Right at the beginning of the war, a girls' school that was struck, and even though all the evidence shows it was the US that carried that out, they've been very slow to admit that they did it. 175 people at least killed, most of them were children. Do you think that was a war crime?
Well, I have to say that in response also to the previous question, that we have to distinguish the political rhetoric from the legal reality. And I have to say, being involved with militaries, training military people, that in the majority of cases, they abide by the law and respect the law. So they're trained and educated to respect the law because there are also consequences, internal consequences. There may not be international law consequences, like international tribunals for many reasons, but there can be internal consequences. Now, with regard to attacks on civilians, on the schools, it could be a war crime. Of course, everything depends on the facts. There is an obligation on a commander to ensure that the object of the targeting decision is a military objective. Of course, everything depends on the information they have at the time. So if it goes to a court of law and on the basis of the evidence, if on the basis of the evidence the commander had at the time, he could reasonably make the conclusion that it was a military objective, then there would be no responsibility. So it could be a war crime, but everything depends on the evidence provided in a court of law.
Geoffrey, we've heard from President Trump that for now he is halting his plans to attack all of Iran's energy sites. I'm interested in these sort of facilities. Are they, under the laws of war, legitimate targets?
Hardly. Remember, and it was omitted by the last contribution, that any act of aggression in war has to be proportionate. And that doesn't just mean, well, this might have been a military objective, so therefore we attacked it. It means if you attack something, and in this case I think it's been said that America likely aimed not at the school, but at the building next door, or the premises next door, which may have been military. Making the decision to do that and knowing about the presence of the school with school children in it next door, then a decision has to be made with legal advice about whether the collateral risk to the children concerned is sufficient to justify taking the risk, given whatever the military objective would be of seeking to attack a different target. And you've got to bear that similar approach of proportionality in mind throughout attack and also those acting in self-defense. And so if you attack something that affects in a substantial way the essential means of life of the people in the area in which you are attacking, you have to be able to justify that in all ways as proportionate to the military objective that you are achieving or hoping to achieve. And the sort of attacks of which you describe feel so indiscriminate and so potentially wide-ranging in consequence that it's very difficult, I think, unless we see documented advice and decision-making by those who make these attacks, it's going to be very difficult to prove that they're proportionate.
Brian, we've had a fascinating conversation about the legality. Perhaps we could end with me asking you, what do you think what are the chances of any actual accountability of any of this ever turning up in a court of law?
Well, I think it's important to recognize that there are various forms of accountability. Criminal prosecution in a court is just one of those. But there's also, political accountability. There's accountability in terms of damage to people's careers going forward. And so there will be choices in the United States for Congress, for future administration, and for the American public, including at the ballot box. Are they willing to hold political leaders accountable for launching an unnecessary and illegal war that has had disastrous consequences, certainly for the people of the region, for millions of people who have been displaced, thousands who have been killed, U.S. service members killed, but also for the global economy and for the U.S. economy? Will they hold these people accountable?
Brian Finucane, Geoffrey Nice, and Nicholas Tsagourias, thank you very much for joining us. Remember to check out our website for more context and analysis. Go to aljazeera.com. We'd like to know your views too. If you have comments, post them on our Facebook page. That's facebook.com/AJ Inside Story. Or you can use X, where our username is @AJ Inside Story. That's it for now from me, James Bays, and the team here. Stay tuned for more coverage of the current situation in just a moment.